Case D 545232, Donohue. Counsel, your appearances and bar numbers.
Good morning, Your Honor. Peter James 10091 here with Susie Lozano Donohue.
Thank you.
Amanda Roberts, bar number 9294, on behalf of the interveners who are not present, and I can explain to the court they're not present.
Is Dad still in the...
Dad's right here.
I know, but he's still in the recovery house or solutions?
No, he's completed it.
Okay, update. I have a note. Intervening grandparents will not appear due to health reasons, and they seek withdrawal.
Yeah, sure. So if you recall, when they were here previously, Rod was on James.
They seek to remove themselves as parties to this case.
Yes.
Any objection?
Yes, and
I
there's
do have
an
an objection.
extremely good reason for this.
And I wasn't aware of this
look-
until today. I just want the court to know if I had been aware, I would have tried to work this out with the
This is
parties.
getting interesting. Okay, so
Remember all the
I think
issues-
I'll go with Mr. James on this issue alone.
Remember all the issues with the Paolo residents? There's two houses that issue Yankee Clipper and Paolo.
Yes.
We tried to move my client to
Dad's
Paolo.
in Yankee Clipper, I believe.
Yes. We did try to get my client into Paolo, but then all of a sudden, Mr. Brown, gotta forget their
The
names
other guy.
now.
Yeah.
Same name as the
Rogers.
DA, Rogers.
Yeah.
There's some weird thing going on with that house being transferred by Jerry to them, even though there was a Liz pendants filed in this case. And he said at the time that that was just over the Paolo residence. There was nothing else going on. The Yankee Clipper was free and clear.
Okay.
Now-
This has something to do with the grandparents.
Yep. Dad claimed Yankee Clipper to his mother
I can address it.
during
No.
as a JPI violation and with a Liz pendants filed.
How'd you find out? You
He
checked
sent
in
me a
the...
letter.
Dad provided notice.
He sent me a letter.
Okay.
I was going to file a motion for contempt of court. He's been playing games this whole time, Judge, hiding Bitcoin, saying he's broke, lying at every single hearing, showing up drunk twice. Now he pulls this stunt.
But he did it, and he let you know about it.
Yeah,
Okay.
but you're not allowed to do this. Now we got to undo all of this. Part of the reason why I'm going to be filing a motion to withdraw is, remember, I'm last in pro bono. I'm well over approaching $40,000 into this case if she were a paying client. And the games he's playing time and time again, we can't go a single hearing without a game he's playing. And of course he's going to come up with some reason why this is valid, never mind the fact that we got a Liz pendants filed to protect it. And that he said before that it was only Paolo that was affected by this transfer with Brown and Rogers and all that stuff.
Clippers, the one the cook claim was...
Now he's saying that this house, Yankee Clipper, is now also going to be clouded title by those people as well. Those are his friends. Oh, he says they're not his friends anymore. One of them was his counsel in this case. The other one tried to act as counsel in this case, but he's not an attorney, so I wouldn't talk to him. But they all work together. They all are friends.
John Rogers.
Rogers has a bar card. Brown does not. And then there was another gentleman that appeared in the case as well, not Mr. Grigsby, but someone else, who is also intertwined with all this friend network. Same thing with Mr. Knoll. They're all friends. They all go. They all know each other very well. They all work with each other, and it's this whole charade that there's now clouded title on all these houses. It's a big shell game, and now it's continuing now. So I want this Yankee Clipper house quit claimed back somehow, in some way, but not to Wyvetta,
Okay.
because that's a major JPI violation. And now I would argue for Ms. Roberts, her scope is she represents the intervening parties. I would like the court to direct her scope and not have her represent Mr. Donohue and his interests.
Are you entering appearance for him?
I am not, but my clients are involved in the quitclaim
You
deed.
speak for your clients then.
I will.
Okay.
So my understanding in this case is what has happened, from my client's understanding, is that the two homes,
Talking about Wyvetta?
yes,
And I
Rod,
forgot her...
Rod is her husband.
Rod?
Yes.
Okay.
So that there were the two homes. I actually talked to Mr. James about it in the hallway. He said that you entered an order allowing them to bring in Mr. Brown and Mr. Rogers as parties to this action, to join them essentially, and the orders haven't been filed to do that. So,
You mean counter defendants or third-party claimants on
yes,
an
because
amended
rather
complaint?
than file downtown a auction to quiet title. So I just learned of all this from Mr. James. I've been calling, sending emails, sending letters, trying to get communication regarding this issue. My understanding is that Yankee Clipper was transferred to my client because there is a sale document on that property as well, and they believe that those houses were being sold. My client is not asserting an ownership interest in it. She's just trying to protect it so that it cannot be sold at the present time, because they're trying to sell the Powell Low house right now.
The list pendants will protect that.
Okay, Mr. James can say a list of tenants can protect it, but it's not 100% guarantee that it's going to protect it. And so my understanding is my client and Mr. Donohue took that action to protect the house, not to divest anybody of jurisdiction. And that house is claimed as sole and separate property. It's been claimed as sole and separate property throughout the entire litigation. So there's nothing untoward going on. They're not trying to divest the court of jurisdiction. I'll stipulate to that on the record right now. In order to get all this resolved, we need to bring the other two gentlemen in, which I don't think Mr. James is objecting to. He just hasn't prepared the orders, so that we can get them off the title to the two houses and resolve the issues. That's it.
But I'm not aware of any.
Okay, so it's a question of how necessary was that quitclaim deed?
Well, it was necessary to
Gonna wipe
prevent
that
them from liquidating that home without their knowledge.
Well, the two gentlemen would
Correct,
liquidate?
Rogers and Brown.
Judge, the quitclaim,
Okay.
the history of this is in 2012, Clark County Treasurer owned the house. In 2014, Mr. Donohue, house is titled in his name.
Okay.
No other documents are filed against it. Got the printout. There's no other claim or cloud on this title when he transferred it over to his mother. None.
James doesn't know the procedural history of what's happened, Your Honor, which is why he actually shouldn't probably talk about that issue. What happened is when they signed the sale documents on the prior house, they also signed the sale documents on Yankee Clipper. So they hold a valid contract to purchase that property, but they have not paid for it. So they have a valid contract to purchase it. So the only way to protect it was to transfer it to my client to avoid someone else selling it.
Signed the contract for sale. Dad only?
Dad, when both houses were
So,
done at the
okay.
same time. Yes, Your Honor. That is what Dad has represented to me.
I need, Your Honor, I need
He
to
can address that
clarify-
further.
I need to clarify that. That's almost accurate.
Okay, sorry.
I'm
Sorry, Your
I
Honor.
haven't brought her up to speed. Good morning, Your Honor. The Paolo house, I had talked about selling it for quite a while, long before this divorce ever started. And the Paolo house it's not valid any longer, was under a valid contract to sell, and I believed it was going to sell. I really did believe it was going to sell. The Yankee Clipper house was never under a contract to sell. However, I was told that I would get $500,000 for both houses, $190 for Paolo, $310 for Yankee Clipper. Both were fair markets at the time. And I believed that would happen because Mr. Brown, I believed, was a very good friend, and he had one hell of a good job. He made a lot of money. I don't know if he does anymore. I've lost touch with him. But the point is the Powell house was under contract to sell. It was a valid contract. In fact, there's two contracts. There's the one that he and I did, and then there's the one the realtor did. And Mr. Brown signed both of those. The Yankee Clipper does not have a valid contract. The Yankee Clipper was a promise to pay. He goes, I'll give you $500,000 for them both. And I said, great, wonderful. And this was
The
before
offer was
the
made
divorce.
before or after the divorce was filed?
My best memory is, well, I do remember telling my spouse that I was going to sell the Paolo house, but I believe the first offer
Both
was
houses.
before.
Before the divorce?
Yes. My best memory is it was the spring before.
Okay.
Now, the second offer through the realtor was after the divorce was filed. That one I'm clear on.
Who made that offer?
Mr. Brown.
Same offer?
Yes, except it wasn't on a form that he and I did. It was on a realtor's form, Keller Williams Realtor's form, or something like that. But Mr. Brown did execute the contract again and failed to fulfill it again.
Either way, we need to bring Mr. Brown and Mr.
Right,
Rogers in
right, yeah,
to
I
correct
agree.
all of this, and we agree it all needs to get corrected. But that
this has
doesn't.
nothing to do with the Yankee Clipper house because he said
My
in
job right now is
court-
to determine the necessity of the quitclaim deed.
The necessity was to avoid them using that purchase agreement to liquidate Yankee Clipper.
There's no offer of proof as to
Is there
that.
any slight chance this Brown guy or another guy will take this house from Mr. Donohue?
He hasn't recorded anything against it. They did record against Paolo. And that's why when
I-
Melissa Dominguez came in, one of the real estate agents that I used came in to try to figure this out, she knew that Brown was so shady with all this that it was ridiculous.
Let's say you two agree that this guy can't be trusted and that he's not going to ever be a buyer, but you think,
I don't trust him.
right, and you think he has something in his hands that he's going to pull the rug from these two and
I have no
Awesome
idea.
goal.
This is a
I have
race
no idea
no
because
to
nothing's been
stay.
presented before. When Mr. Donohue said last time
Okay.
that the only issue
I
was
think
over
you're all on the
Paolo.
same page in terms of let's protect this house.
Yes.
Right.
But the way they did it, he didn't tell me that, hey, Mr. James, we got an issue with this
Was
house.
there a
we might
better
lose it."
way? Was a better way to do nothing, or a better way to protect the house? That's the question.
We could lose the house if nothing was done. It's a
How?
race no to state.
How? There's nothing recorded against the property.
Right, but I recorded first to avoid him being able to
I have a
record
list of
first.
pendants filed on the property.
It doesn't. This thing
Now,
that
I don't do real property law, but we know Law School 101 on.
But the list pendants doesn't protect it. I
Property.
have it going on right now in a case in front of Judge Hughes. It doesn't automatically protect it like we think that it does as attorneys. Lots of people do shady things on houses. It doesn't, just because there's an order, sometimes they go
Is his
behind it.
signature is out there somewhere, and this guy might be holding a document and record it?
Yes.
Yes.
That's why he said he raced
That might be
down-
enough more to convince me, because he's got some document. He'll go run to the county recorder's office, and then he may cloud the title.
You can order, and I will instruct my client that she cannot liquidate that house.
There will
and-
be an understanding in this courtroom that this house wasn't transferred to Wyvetta to do some kind of community waste or fraudulent action. Court's going to acknowledge that. If that is our only protection right now, unless you find a different way of protecting the house, yeah, we don't want this, you guys say, shady guy, to file something with the county recorder. And the understanding is this is not, Wyvetta takes no interest, and I wanted her to sign a declaration or affidavit. She has absolutely takes no interest, that she acknowledges that this is a potential community property unless it goes to trial on separate property claims.
But
If
then-
there's a better way you can think of, Mr. James, it might be right now just to err on the side of caution, and there's no finding and there's no acknowledgement, and they make that representation. If you want an affidavit or declaration from Wyvetta that this is just purely for that purpose, then we were going to preserve this house until trial.
That's fine, Your Honor.
Okay.
For as a stopgap measure, that's fine.
But then, as far as it goes for
They
them
stipulate.
liquidating or for them interfere, okay, my clients can't be here, Your Honor.
No, but she can sign an affidavit or
Yes.
sworn declaration that this is the reason why.
This is absolutely true, and I will have them
Quickly.
do that. But they cannot come back to Nevada. They cannot. His health is.
Oh, they're in, where, are they, Wyoming or something?
They're in Arkansas.
Arkansas?
I'm sorry, Your Honor. I should say.
Okay.
They're in Arkansas right now. His health is dire.
Understood.
He has heart and lung issues. His prognosis
Sorry to
is
hear
not
that.
good. If he came back to Nevada, it is likely end of life.
Okay.
So he cannot come back here to do that.
No objection, no objection there. You file an order to remove themselves as interveners.
Okay.
In this case,
I will-
we're down to,
Your Honor, while if you do that,
Oh,
we
because of the
retain
quick
personal
claim?
jurisdiction over them in this case. We
how
have personal
can,
jurisdiction
is there
over
any
them.
harm, no foul, if they just remain on because of the quick claim?
And I'll stipulate to
And
waive appearance.
they're not going to be pursuing any custodial,
As long as we have an order that says that you can't release.
for only the quick claim
for
purposes,
that
they
purpose,
just
that's
listed
fine.
as
I'll prepare
parties.
an order that says that.
Fair enough. And
Okay.
they're not here to take custody or get involved. Their health is going down, and it's only for preserve the quick
That's fine,
claim.
Your Honor. I'll prepare an order.
I appreciate that.
Yes.
Okay.
Now, as to some other issues, Judge, one, Mr. Donohue and I spoke briefly before the hearing.
Yeah.
We both are in agreement that this case is not ready for trial.
Oh, wait, before you do that. Can we vacate my motion? Because I had to file a motion on this, Your Honor, so before the calendar, it's at August 22nd. Can you vacate
At
that?
2:30 in the
No
morning?
objection.
Yes.
No opposition, please vacate. Motion to continue trial.
Thank you.
Parties will stipulate verbally in court today to continue the trial. And I got to put you on the priority list, but what month you want to start looking at? When would you be ready?
Well, and that goes to the second issue is We were supposed to do some evals. That got all messed up. We submitted stuff to Your Honor, and we haven't heard back as to what the scope was to be, to clarify again. So once we get that, we can go forward with...
We did get it back.
For the record, when did he graduate from Solutions?
Yes.
In May? Oh, when did you graduate from Solutions
Well,
Recovery?
It's slightly complicated. The in-residency...
Inpatient.
Right, was at the end of April
Okay.
or 1st of May, I don't remember the date.
Yeah.
And then the outpatient, which was 3 times a week for half a day, 3
Intensive
times a week,
outpatient.
just finished last week.
Okay. And you're now just on aftercare follow-up once a
ma'am.
month?
I have to call Jane and ask her. I'm not sure, honestly.
And you are in recovery
I am so far.
for alcohol?
Yes, ma'am.
Okay.
So, Your Honor, as to the evaluations, this is what happened.
Which evals are you talking
So
about?
we were supposed to do a custody evaluation and reunification.
That's right.
So Mr. James sent a letter to the department, and I can pull it if you want the dates, what happened, asking for clarification if you wanted a full custody evaluation or just a brief evaluation. You responded with a minute order and said this was supposed to be an emergency full custody evaluation.
Yeah.
We agreed that we would use Dr. Holland at that hearing as the first choice. I have
Right.
the video citation. Then there became a dispute about using Dr. Holland or Dr. Mullen. You indicated that your order was Dr. Holland was the first choice. That video citation is 095437.
Okay.
We agreed to use Michelle Gravely for the reunification, but neither have commenced as we stand here. There's been some disagreement regarding Dr. Holland, although she is able and willing to do an expedited evaluation.
She's on standby. Got it.
So, Judge, just point of procedure, I appreciate the assistance, and my office is going through some staffing issues. I got 2 new staff members and a new case management program, so I am
I can
getting
imagine.
back into everything in my cases.
Okay.
But given that our clients are no longer seeking anything, we need to kind of modify what's going on because they are now, for that part of it, out of the case.
And I was just providing the court with the procedural history.
Yeah,
Yes,
Grandma,
yes.
Grandpa
But as it
can
applies
no
to them,
longer.
because they were going to be involved in it, and there was,
That's a
there was
given.
something with them being part of this that no longer is the case. So I think it's a change in scope. And
What's the goal here? Mom wants primary for sure, or sole physical,
Sole legal, sole physical.
and Dad wants joint.
Yeah, sure.
They're still at odds. So, and nothing is determinable until trial. Everybody gets their day in court. But, you know, we're on temporary orders, and Mom having temporary, I believe, sole legal, sole physical, because he went into rehab. And
It was actually well before rehab she was awarded that.
the question is it still worthy enough to do the evaluation to
Yeah.
sort through both sides? I say yes. I'd say yes. And Holland's on standby. Do we have funds to pay Holland, or was she
An
prepaid?
order
No,
that the
we would-
Bitcoin would be held by Mr. James's office, and that money would pay for it at the prior hearings that I was
Could
at.
be. Do you
Yes, Your
remember?
Honor. The current balance on that is $36,300.62.
Okay.
Now, there
Holland
was
wants-
issue with Doc.
Sorry, 36,000. Will you just tell me so I can take my notes?
30. Did you get the
36300.62, but it doesn't concern her or her client. So,
Well, we like to make a notation of the current balance, so 36,300.62?
yes.
Okay.
There is, Dr. Holland, if memory serves correct, Judge, there is an issue with her being able to do it. Her staff would be the one doing it, and it would still be delayed. There's a big delay with her office. We would prefer Bree Mullen do it.
You care
Or
one way or
one
the
of
other?
the new ones, Sunny, I can't remember her name. She was one of the other ones that we discussed.
Got the list? Can I have the list? Okay. Well, Mullen?
No, we agreed to Dr. Holland for a reason.
But to your honor, she is now arguing beyond the scope, because now she's now arguing for parties that have no stake in this interest, and she does not represent Mr. Donohue.
Your pitch is Holland will be as slower than Mullen.
Yes.
I'm the one that's been talking to them. Mr. James has not. I've been doing all of the legwork on this issue, so I don't know why he wouldn't want me to talk about these issues.
Is there, we understanding it wrong that Holland is ready?
Holland is ready, willing, and able. She was able to do it within the time frame prescribed and get it done
What
before
time frame
trial.
we given her then?
We had given her 45 days, I believe, was what you instructed because you wanted it done
I
before
need to get a
trial.
bottom of that. If both can do it, I said Holland, then it'll be Holland on the record, and she can do it, meet the deadline. There shouldn't be any objection to Holland if, unless there's some other basis to object. If we
It
set
was-
the deadline,
It was timeline, and her staff would be doing it, not her.
That's not true,
And-
Your Honor. Mr. James is incorrect. He never had the conversations with Dr. Holland. It was his staff and me with joint calls.
if it's Holland's office, there are court certified approved. Okay, but if you wanna, I don't know, I mean, you're gonna bring an issue that because her staff does it under her supervision, and she, like in-home studies or home visits, you
Right.
know, that can be done by a staff member, but the actual, you know,
But I don't understand why Ms.
can
Roberts
administer-
is arguing because her clients, she has no standing before the court to even talk about this issue.
Because Mr. James doesn't have the information, Your Honor, because he wasn't doing it.
I'm not going to go circle back, but if I said Holland on the record and Holland can meet the deadline, the answer is Holland was picked before. So what's the deadline? Because we're resetting dates and stuff.
Ms.
And-
Roberts is mooted out on this. So,
And Mullen, you'll be your backup. I have no problem with that. But we will find out when we set the deadline, and first come, first serve. We gotta give them a reasonable deadline. Was 45 was the original, and they haven't even started anything?
Ms. Roberts should not be arguing or even
January
talking.
for
Donohue should be
definite,
speaking.
but we can always put you on priority list for any month that you prefer. So I can have some placeholder dates right now for, you want a day and a half to start on custody? We're going to do custody first. If you resolve custody, settle it, we will convert it to property and debts and alimony. What do you have in actuality right now? And give it to them. Wednesday and a Thursday, day and a half.
Wednesday and Thursday would be January 23rd at 1:30 p.m. and Thursday, January 24th at 9:30 a.m.
That's my last. You got the last week of January available. Otherwise, we're into February. And then you tell me you want priority list for. You know, it's now July. You don't want July. You don't want August. You don't want September. We're going to start looking for October, November, December. Then, right? You need 90 days more of discovery.
October's great, Your Honor.
Starting in October, they're on the priority list for October 4th. Is that suitable with you, Mr. James?
Well,
And we don't, unless both attorneys agree their availability, we're not just going to say you're going to come in October. We need both sides' consent to have their clients.
So just so I'm clear, for Rod and
But-
Wyvetta, they don't need to be here for the trial unless there's a purpose for them testifying. We could do it by some alternative means because of their health.
If they're bedridden and can't travel anymore, it might be a compelling circumstance.
Okay.
I know what they look like. You know, if they're going to testify from
Okay.
they can't travel, file the motion. File the motion.
yeah, but they will be witnesses, not parties. So that's only if
Witnesses.
if they are
Yes.
necessary.
Yeah, they are just kind of, what do you call it, nominal witnesses, nominal parties now. It's only for purposes of the quitclaim deed. Okay.
And once we get that resolved, then we can.
Roberts will get that in writing to you, Mr. James. Okay.
Now, but it also comes into
45, you think 45 was what we talked about. What's 45 days from today? Mid-August, we'll be done with this emergency evaluation on custody? And we'll see then. There's a lot of records Dad's got to turn over.
So that's what
Uh,
Your Honor, can
And-
we put a little,
Ms. Roberts, are you going to represent Dad?
Potentially, Your Honor.
She would have a major conflict of interest.
That is my issue to deal with, not Mr.
If they stepped in the case and they're not only here nominally, what potential information could she have shared? Because
They said that Dad was unfit.
that may not be so. They may just say they'd like to step in Dad's shoes if he cannot do it.
After making a claim for
Plus,
they're unfit.
they also had their grandparents' visitation. Is there any? I don't know what you want to get an opinion letter?
I don't, Your Honor. I know what I need to do if I'm going to step in to represent Mr. Donohue, and everybody knows.
If she did, and I got to the point of that, I would say for trial, you'd have to get a co-counsel under DiMartino case.
I have to get co-counsel under the case.
Yeah. I don't know. You'll have to determine I have to determine if there's a conflict of interest. You kind of put me on the spot there, but what information have they shared that would be adverse to your client's interest? Other than,
Adverse to whose interest? Mr. Donohue's interest?
yeah, grandparents would, he's saying there was maybe statements made or position's taken that his dad's unfit, or it could be that they stepped in because dad was going to be in rehab. So, and
I can
plus their
represent to the court
grandparents'
that-
visitation, but they've withdrawn grandparents' visitation.
Right, Your Honor.
No, they tried to step in for custody, not grandparents' rights.
Your Honor,
They
if you'll
tried to step in for
recall,
custody.
I can address
There's
it.
never a permanent custody deal, though.
If you'll recall,
Backed off from any temporary custody deals.
Donna Wilburn was actively involved in this case until she was removed for bias. Donna Wilburn is part of the reason that her recommendations to the court are part of the reason that my clients filed to come into this action, Your Honor. The conflict would be potentially between Mr. Donohue and his parents, and I addressed that, not Mr. James.
Parents are elderly and of ill health. They're not pursuing anything, but the appearance of what possible information Ms. Roberts got from the grandparents that would be not adverse to dad, but adverse to mom. That's the question. I can't think of any right now, but if something is persuasive enough, then I would say you have to get a co-counsel. Maybe I won't look at the DiMartino, the standards. Do I impute something on you or disqualify you or allow you to stay on, but for trial, maybe to err on the side of caution, you got to get a co-counsel.
That's fine, Your Honor.
But usually DiMartino is if you potentially become a witness yourself.
And I would not be a witness in the case, Your Honor. I have no personal information.
Now it comes down to,
I may have to have a sign a declaration. There's no.
I have never met with him outside my office. I have no personal information. I've never seen these children. I don't know what I would possibly test.
Right now, it's an oral motion to. If you do it if you make a formal entry of appearance, it would be an oral motion to disqualify. We can get there when we get there, and then we'll analyze it under DiMartino and that other case. Okay, you can date this.
now, there is the scope of my continued representation, Judge. I touched on this earlier. I'm going to be filing a
Yeah.
motion to withdraw.
You're not ready to make an oral one? You want to stay on the case for a little bit?
There are some things I need to get done in the case, back orders, before I can officially get out.
Okay.
But I'm putting the court on notice that I will be withdrawing. The court did say.
I mean, I could let you withdraw, but you're still responsible for doing your orders and stuff. Any
Right.
outstanding orders, but it's up to you.
I'll submit it and then Zoom it, Your Honor. The court did say for 3 hearings now.
I can make it easier. You don't need to submit in Zoom. Do you oppose?
I don't oppose, and Mr.
Nobody
Donohue will-
opposes. You may file a notice of withdrawal.
If there's outstanding
I'll
orders and
accept
Mr.
that,
James
or
wants Mr. Donohue to do them, or have
spare you a motion. You said you're out of fees, or you're not getting paid enough. You can just file a notice of withdrawal. I accept it. I'll say it on the record. No motion necessary. You waive any requirements, right?
Yes, Your Honor.
No objection, no opposition. Anytime he officially wants off the case, he may file the notice of withdrawal. From the date of filing, you can talk to mom directly.
That's fine.
Okay.
If there's outstanding orders
rehires
that
him,
to
yeah.
be done, and he tells me or Mr. Donohue what they are,
Wrap up stuff like orders, I don't have a problem, even if they're withdrawn from the
they
case.
can do it even, so it's fine.
Okay.
But Judge, you've said for 3 or 4 hearings now to keep reminding you about this, so I'm going to remind you about this.
Okay.
This is a case where Mr. Donohue has been hiding funds and playing games with the money.
Anything emergency, like we can get to trial on that.
He hid the Bitcoin, but we're going a different
I
bit.
disclosed
Okay,
it
wait,
on the
does it have to
affidavit.
do with attorney's fees? Because I don't know if that's before me today.
It is, you said for 3 hearings now, or 4 hearings now, to
You're right.
remind you
Okay, you could be right. Okay.
about attorney's fees.
Well, you'd like to stand,
Bring it up next time, because there is
Funds.
$36,300.62
we gave
of community money.
you, how much we give you?
I've had 2 so far,
How much?
2,000. And I've expended, if you were paying
If we do
fine, which
Holland or
this-
Mullen, that's going to be about what, 5?
That's not community money. That Bitcoin
on.
was not community.
Hold on.
The,
Standards
Holland,
are
I think
sergeant v. sergeant, standards are sergeant v. sergeant, 18010.
I think she said, I think, and I'd have to go back and look at the notes, but I think both of them started, their initial starting retainer was 4,000, and both of them said it could go above that depending on what they had to do.
Yeah.
And I'm sorry, Michelle Gravely's retainer, correct me if I'm wrong, Peter, I think that one was 3,500 to start the reunification.
Double that to get a final report.
I
Maybe
was
she's going to run
And I will
about
tell-
7.
Yes, we're closer to 7,500.
Okay, and I could be wrong, there's a lot
How are
of,
you paid?
my clients paid me.
Oh, from
They
there.
have an outstanding balance with me.
Well, if I give Mr. James to keep him on the case, and if you enter the case, would give you likewise.
My concern is that if you take money from that Bitcoin and we have Michelle Gravely for $3,500, and then he says,
Figure they double it to get the final report, so she could be 7 to 10.
well, the issue is, I talked to him.
Still
I
leaves
talked
us
to-
26.
I talked to Jerry about it. There's no order for visitation right now. Mom has let him have 3 visits or 4 visits since he got out of the inpatient rehab. He's only had 4 visits.
And Your Honor, she's arguing for Mr. Donohue.
Sergeant
not
v.
counsel.
Sergeant. Sergeant v. Sergeant. Community funds may be set aside, or even
And
somebody's
separate
separate funds,
And separate
to ensure that the wife meets the husband on equal footing in the courtroom. There are funds available.
And Miller
if-
versus Wilfong.
If you want me to be fair, if Dad would like to request fees as well, then his attorney will be paid. If he hires you, we can give both of you equivalent retainers. Additional retainer, Mr. 2 total, plus
No,
the,
total, that's it.
and the amount of hearings in this case,
And all
I
the
can
stuff
see
that Dad's
why you
doing,
would
keep
want to
it back
withdraw,
in.
but Mom would like to keep Mr. James on, right? If he had the funds, if you had the funds. Or you want to save that money, you want another attorney? It won't be, you'd like to keep Mr. James, okay.
But everybody's talking about protecting the houses and nobody's helping to protect the children. We need to be in one of the houses. I need to.
We
be able
haven't
to
even
fight
discussed the children,
in a
ma'am.
common ground.
Ma'am, not helpful.
Sorry.
Please have a seat. We're talking about the money now. Doesn't mean we're ignoring the children, okay? I understand this is an emotional time, always been for you, and your main concern's the children, but the attorneys have to do their job. We have to make sure everything's in place, so we're not going to work in chaos. I'm putting it out there. If there are fees, there's 36 there, back out 7 to 10 for Mullen, and then you still got adequate fees to even give you guys at least, if I give
Your Honor,
one to him,
please
I...
allow me to address that. I'm not arguing with you, but I do want to make it clear, because I've said it once before, that of this money, I don't know the exact amount, but approximately $10,000 has to be paid as federal income tax.
He's already got that money, Judge.
When did I get that
We
money?
backed that out. He did not transfer that over to me. He kept that himself when this money was transferred.
Not that I remember doing that, but I can double check on it.
On the record, he said
Absolutely.
that to me on the record.
Yes, it's on the record.
I
It's
kind of
in the
recall
minutes.
it.
I recall saying, Your Honor, I need to keep some money for the
Not
federal
that he
income
did
tax.
keep the money.
Right, well, but I don't remember keeping
Did
it.
you put it in a
He
bank? It went into a bank account originally, right?
Well,
No,
when
it's
you
Bitcoin.
yes, when you sell the Bitcoin,
I-
it goes into the.
I'd say, I don't know if I ordered you to get an accounting of that.
You did. He didn't do it.
You still owe Mr. James an accounting.
All right, I'm sorry.
It went in a bank account, and something might have been set aside. The bank statement won't lie.
Yes, I agree with that.
Let's
I'm not
get the
trying to
bank
hide
statement.
money.
So if it's 36, back out 10 from Mullen or Holland, back out another 10, you're still 16 available.
Yes, ma'am. I just wanted to make it clear
Oh.
that the taxes are due. Well, not due, but they
Worst
will
case
have to be
scenario,
paid.
if they are, if they,
He has
16,
the money.
16 would be available. You want me to cut that in half, give you 8, give her 8 on just on retainer? And then that'll pretty much could potentially wipe everything out, but
How much did you leave for each of the evaluators? You left
10.
There should only be one evaluator, though.
You want,
Reunification you ordered too.
you said, did you say Mullen? You said you wanted Holland. She's a full, yeah, she's about 10.
Okay, so 10. I know Peter.
We'll make 26, 36 minus 10 is 26. If the taxes are true or not, worst case scenario, you back out another 10. There's still 16 available. If
You
I,
have to pay the reunification expert.
how much is that?
She said her retainer to start the case was $3,500. That's Michelle Gravely. That's who we agreed to use.
Then you would get a proportion, you get nothing, or I give more of it to Mr. James.
$5,000 each until we figure out what the evaluation costs are.
Better than nothing, and it's nice to have attorneys, 2 attorneys on the case. Okay, 5 each for now, and he'll hang on. It's, he still has my order. You can file a notice of withdrawal if all funds have been expended, and you can account for that. You are hired, right, as for $5,000?
Yes, I do intend.
can
I haven't
discuss
signed the paperwork, but I do
You need-
intend on hiring.
But
I'll get the
the
paperwork
monies
done.
will be set aside. If you do not hire her, the monies will stay in Mr. James's.
That's reasonable. Thank you, Your Honor.
What else? Now he's out of solutions. He's in past IOP. He
filed a
would be
motion.
on as-needed basis and attending AA meetings. How many a week?
Your Honor, I make 1 or 2 a week. I mean, I could go more if I had to.
Working for you? Do you have other support groups? You have a sponsor? You have clean sheets?
Well, yeah, I have a sponsor I don't particularly like, so I think I need to change.
Find another one? Okay.
Yeah. Just, give me a couple of weeks on that. I'll get it
You
done.
drive, have a license?
Oh, yeah, I never did a DUI
Okay,
or
just that-
anything.
no, just
I never.
ask.
Could we address, Your Honor, his law license? Is that possible? You have the information regarding that? Do you
What does it
remember
have to
that?
do with me?
Well, okay, so in order to get his law license back, he has to pay restitution. Do you remember any of this?
Kind of.
So his employees were stealing from him, and they ended up having a trial. He was represented at the...
How much is he on the hook for?
And Your
A
Honor,
lot.
Well, then, yeah, I can't.
Well, no,
Like
he can...
six to. I'm on the hook financially with all the requirements for.
Bottom line, he needs to get his license back.
If he pays $8,000 in
Approximately.
restitution plus the fees to go back and do the CLEs, he can get his license back. Then he could start making money again.
You asking from Mr. James's trust account?
I think it's reasonable, and he could pay it directly to the state bar, and I get all the arguments that
I think
they're...
I'd like to have him get his license back so he can make money.
But then he could get the CLEs done, do the things that he has to do, and we could give Mr. James the orders.
Ask would he get it done if he had the money today?
I have no idea. I got to take some.
Probably how long?
I can get the order from the
Hey,
state
wait.
bar and tell Mr. James how long it would take.
Work with a law firm or hang his own shingle again?
Oh, I can't do
He
that.
can't go
I
out on
can't.
his own.
I-
Do you have to be hired with a supervising attorney?
Yes.
Any job leads?
He can't apply really until he gets his
Right.
license back.
Your Honor,
I played
counsel's
for
arguing,
paralegal.
but he
Sounds like
also
that'll
said he was
take
gonna
several
pick a
months.
job up in Elko.
No, I didn't. I never said
You
I was
said
going
that
to.
it
I
also
said I
in
applied
court.
for a job. I had 2 interviews.
Yeah.
I didn't say I
He
took
might have
a
said
job.
that, but he wants to stay local, be near the kids.
Yeah, but it begs the question, Judge. He's got money. How is he paying the HOA? How is he
Paying
paying
another
for
10.
his food? How is he paying for everything going on? He's got a pretty clean haircut right now, Judge. How is he paying for all this?
As
He was
the,
hiding the
get that.
Bitcoin, and we don't even know
I
if he
didn't
gave us
hide
all
it.
of
It was
it.
disclosed.
No, he did hide it. It was
36
not
minus
disclosed.
10 for
It was
Holland, minus
completely
10 for
disclosed.
taxes. But once we get to the bottom of the taxes, if there's 10 for taxes, he'd like to use that.
He already has it, Judge. I can tell you, as an officer of the court, he cut me a
Is
check.
it an
Let's let that
unrealistic thing to him to get his license back? Because there might be conditions with the state bar. He can't hang his own shingle, but he can get a job as an associate or with a supervising attorney. But they will pay him, what, a meager salary? So then all the rest of his salary would be redirected to the restitution to the victims?
No,
First
he
of
only
all-
has, the total restitution is only...
Or is it to the restitution to state bar?
No, he has to pay it to the victims through the state bar is the way that I understand the order works.
Got it.
But it's only the $68,000, so it's not one of these where you pay he has to pay it back to get his license back because it's such a small amount.
An associate would be hired at what, 36, 46,000 a year? 50, 60,000 a year? If
In
it's
this
60,
climate,
I don't know. I've been a judge for
I'll
years.
hire him today for $30,000. Once he gets his
I
license
don't know the
back.
going rate, but
there also is
that
an issue,
can
Judge.
take some time, and by that time we're in trial.
But I
So it
think he
might
can-
be kind of a lost cause because he can't make money right away. He's got conditions with the state bar.
But as soon as he pays the money, he can get his license
Tell
back.
you,
with
if
the
he
state
gets
bar.
charged 60 grand a year, 40 of it's going to go to restitution. 20 is what
No,
he's
Your
gonna
Honor, you
live on.
misunderstood. The total restitution he owes is $6,000 to $8,000.
6 to 8.
Yes,
oh,
not 68. 6 to
4
8.
digits, not 5.
Yes. So once he paid the restitution and did the CLEs, he could get his license back.
With no probation conditions.
Well, there's some
On probation.
but not extraordinary ones.
I don't understand why counsel is arguing, Judge. There is no standing.
He's pushing for Dad to make money so he could pay his child support. So
But
Mom
she's
can
not-
get some alimony.
She's not an attorney at this point, Judge.
I know. I know.
Mr. Donohue is an attorney.
well,
He's fully
was.
capable of
I could
representing
status
himself.
check you and give me the taxes deal. He's swearing up and down I don't have any money set aside for taxes.
He does have it,
That's
and
fine,
we also
Your
don't know what else he hasn't given us.
Because what does that mean to me? That if you had actually set it aside in the bank statement, you're not supposed to spend it.
You know what? I
Segregated.
don't. I was drinking too much. There's no doubt about that. I don't
Okay,
remember
stop.
spending it,
You get me an accounting.
but maybe I did. But I don't
I'll
remember
check
that.
you back when I get back. I can check you back as early as July 9th. I'll be in court. I'm in trials all week, so I'll put you in for a quick status check. And then we have 10 more potential. So I can get you guys your 5. We get Mullen or Holland, they're 10. And then if there's 10 that can be traced or not traced, depending, then we can get that to the restitution. You don't want that hanging over your head.
My client needs money also. She's
All he needs.
she's barely surviving. He's living
Give
in
her
Yankee
something-
Clipper. We'd like to move her into Yankee Clipper. He's got other money. He's doing
I
something.
don't have
whole
other money.
new-
How's he paying for his gas? How's he paying
Boy,
for everything?
It's all
if he has
going on my
zero
credit
money?
cards.
And we don't
I don't
have
remember
any of
what
that
was
information.
distributed to her last time, but how,
I think either 1,500 or 2,000.
A lot,
10,000.
we were supposed to hold her over till trial.
And now,
Trial's gonna be moved. And she needs another disbursement.
yes, Your Honor.
And she said she is working part-time somewhere?
Yes, for an attorney.
Part-time,
Robert.
part-time. No changes?
Or you can
It's as much
consider
as she
this, can we have them file FDFs?
Can you hang on till like the week of July 9th and I'll status check you on that and you can make a formal request in writing to the court? And updated FDF?
Yes.
Yeah, it can wait. It can wait about 2 weeks.
We also need the spare key to her car back.
Back end of the 9th. You have any room? Huh?
We need the spare key to her car back. Mr. Donohue has it.
Of course, I have a key to my car, but it's just for the door. It won't do the ignition. The ignition
It's
is
her
chipped.
car.
Fine,
We
just-
need to get it back.
Ms. Roberts? Oh, I'm sorry.
She's not counsel.
I had it.
Oh,
He took it from her during the last,
That's
several
fine.
months.
I don't mind giving it to
Oh,
her, but
thank you, sir.
it's the
Done.
my car part that's not right.
That's fine.
I've,
Can we give the key now, Your Honor?
But it's not the ignition key.
you
It's
have
only
the
a door
key?
key. No, I don't have it.
duly noted.
We'll deliver it to Mr.
It's on the
James's office
keychain
within
she
a
left
week.
it on.
Thank you.
When she moved out, she left the key there.
No.
All right.
He took it from her during
That's
the
not
litigation the
true.
last several months.
We're not
Stop.
here to bicker, but he says yes, she can have it, and it's just a door key, whatever, or ignition key, I don't care. And you need to fax over or email your something to show retainer agreement signed, and Mr. James will cut you your check for $5,000 to your trust account. 5 each, 10 reserved for Holland or Mullen, and then when we come back and the back end of the week of July 9th, are you guys available
What day?
for a
Thursday, July 12th at 9.
I'm actually in, I have 3 hearings that day, Your Honor, and one of them's a trial.
Oh, yeah, I'm all backed up that day
Are
as
you
well.
looking on the 11th?
The 11th, I could do something before 11 a.m.
I have an all-day trial.
How about the 10th?
The 10th, I would be fine on the 10th.
I have deposition, calendar call,
How about the
and
9th?
trial.
Monday the 9th?
As long as it's after
No,
the
because it's
11th.
coming out of the 4th of July holiday and judges are back working.
9th, I'm available.
The 9th will work as long as it's not at 9 a.m. I have another hearing.
I have, they're my trials, so I have a half-day trial, and I have another half-day trial in the afternoon, so I'm booked. What would be, let me look at my calendar if I can get you in, like, look at the week after. How are you guys looking for the week after? And how about I do this? I'll come here at 8:30, and if there's room, I can make you the only 9, so you'll have an hour instead of a half hour.
The following week, I'm good. I just have motion hearing
Well, yeah.
sporadically.
I'll have to start court early, 8:30 to 9:30ish, but I have to see if there's any room. Starting the week of the 16th, I'm it's pretty heavy, but
18th works great for me.
the 18th, yeah, let me see if I have room. I got chambers calendars. I got 2 9s, 2 9:30s, 3 10s, a 10:30, a 1:30. But who's the trial? I can like delay the trial.
That's me. That's my trial at 1:30.
Is Watkins going to happen?
I think so, yes. But you could delay it if you wanted.
Well, Compton won't mind, but if I get you in at 1:30, I can only squeeze in a half hour, and I got to start your trial. No chance of settling? We've tried before.
Yeah, I don't think it's going to settle. Do you want me to ask Steve if there's a way to move it?
Well, I can start you 2:15.
Okay.
I can give you guys 45 minutes here.
That's fine.
On which day, Your Honor?
Strolling at 2:15. The 18th, Wednesday. I actually had a meeting with the DAs and other people, but I'm
Do you want me to talk
Um,
to Steve Compton and then get with Susanna?
you know, I'm canceling a meeting I am supposed to go to.
Let me see if I can talk to Steve about it then. I'll make a note and call him today, and then I'll call
About
Susanna.
the 2:15 arrival? Yeah.
I'll
Don't
call
worry
Steve
about my meeting. I tell them set it on Fridays when I'm not in court, and they
Well, I can
they
talk to
set it
Steve
on.
about moving it maybe. Let me just see.
Any slots left on the July? I can move you up. That July week, the July. Because Jason's trial didn't want to take it.
No, I'm in an all-day trial that day.
No offense, Jason. It wasn't even you. I think it was the dad didn't want to take the dates or something. I don't know. Oh, you can't do the. Okay.
Yeah, I can't. I've been.
If I.
But I'll talk to
So
Steve.
you want to use the afternoon on just the Donohue case?
No.
Oh, we'll start the trial at 2:15, 2:30. It'll be an hour, 45-minute to 1 hour delay, but it's not going to finish probably because it's this alimony issue.
Complicated. Well, it's very
Yeah.
complicated financially.
And we'll get it started, and I can. If y'all want to stay till 5:30,
Let me just talk to Steve, and then I'll
I can do a little overtime, but I'm not allowed to really.
Okay, we'll talk to Susanna.
I can make up that half hour or an hour, no later than 6 though. I can do 1 hour overtime, but I will not, I can make up that hour by staying past 5 to 6.
Okay.
But I do start promptly at 1:30, so I can get you guys maybe 1:30 to 2:15, and just let us know. Let Susanna know. Either way, you're coming at 1:30. That's
Yes.
set in stone. Okay.
And I will be here for that.
And I will, anything you filed, at least if it's on a Wednesday, by weekend, because I get so jammed up. If you file it by the weekend, I can have your updates by weekend. Everything's briefed by the weekend. Okay. But I'll keep my law clerk on alert for that, because anything comes.
Are we just calling it a supplement? Is that what you want to?
Supplement.
That's fine. Okay.
What issues you want to discuss with me? Right now, it'll be mom's living expenses. The taxes accounting, I'll need that accounting on the taxes on the Bitcoin cash out.
Yes, ma'am.
It's 2 issues I've identified, and then everything falls in place. Like the attorney's fees are already ordered. Ms. Roberts get the retainer agreement or proof of it. She'll get her $5,000. Mr. James can distribute $5,000 towards his bill, and he'll remain on the case.
We're agreeing, Your Honor, to file the FDFs by July 9th. Just so
Okay.
we both have them.
For $5,000, you will remain on the case until how long? You certainly can't do the trial without getting paid.
No,
And
That's
are we going to
gonna-
get some more funds out of a sale of a house?
that's going to push me through for a while, Your Honor.
Okay, I appreciate that. It's not a lot, I know.
We
But
really need to get the order done on Mr. Brown and Mr. Rogers.
Can we
to
get
them
other
in.
monies from the community to get?
I'll work with
The trial.
you on that, 'cause that was something that I'm not.
I have no idea what's going on with Palo Verde, but more immediately,
Property.
mom's working part-time job and she
Stroke.
needs living expenses.
Quiet title downtown, so I think it'll be easy from here.
Mom will need living expenses till the January trial, so that's going to be that's coming up soon. Yeah, we're just going month by month on this.
Okay. If she gives me an FDF, I'll talk to Mr. James.
Bring me up to speed. I didn't want to do with Palo Verde. Is that
Well, we need
sellable?
we just talked about that out.
A realtor?
No, we need to get Mr. Brown and Mr. Rogers off. So we'll file to bring them in. You already ordered that we could do that, or that Mr. James could do
But
that.
bringing them in may not solve anything.
Well, we can at least address it.
You can resolve it
You
though.
can resolve it.
because you're a district court judge, so we don't have to have two competing actions.
Their
Under
interest,
versus Malik, we can do this.
their interest in the house.
Yes.
They can get their own lawyers then. Okay. All right.
They would have to if they
That'll
wanted.
be like something like a summary judgment motion as
Yes.
a matter of law.
Yes.
Okay.
Well, at least we'll figure that part of it out. but
You've got
to
the
bring
rest
it
of the
in-
year to hear that motion.
It's a quiet title action within the divorce, really, is what it is.
Who's filing the amended complaint that you guys stipulate to?
To bring them in.
Yeah, wouldn't it be an amended complaint?
We're doing that by order for them to appear.
I'll go through the court minutes and I'll figure it out. And if we need an
I think
amended,
you bring somebody in as a party. Oh, order permissive joinder?
We'll figure it
I'll
out.
check. I'll check.
How
and
about,
give-
yeah,
They
I
made
think you need them.
themselves, they kind of brought themselves in with
They
the
need
filing
to
of
file,
the
one of
conveyance.
you will have to file a motion for joinder or intervention. Motion to, or interplead.
Mr. Knoll.
Your Honor, they filed, Brown
We'll
filed a
figure it out.
notice
James,
of
Peter and I will,
conveyance
we're all
when
in
he
agreement
recorded
regarding
with
this.
the
So
county.
we'll file something to get it on. Maybe we could do a stipulate. Oh, we can't.
Tell you what, you got till the
We'll work
July 18th to let me know what
Okay.
actions you parties are taking.
That's fine.
Thank you. The adding of 2 parties, Mr. Brown, Mr. Rogers, will be on the table for July 18th as well.
And, Your Honor, just for clarity, there's a corporate a trust or a corporation that has legal
Any
ownership of the house.
Potential entity may
Yes.
be named
Well,
in a civil
Mr. James
action.
and I can address that.
Appreciate it, thank you.
Thank you, Your Honor.
Thank you, Your
Oh,
Honor.
what?
Okay, we need some orders from today.
I'll prepare the orders from today.
I appreciate it,
Countersign.
even though you only represent the grandparents.
Right, I'm gonna do a separate order as to grandpa and grandma.
Are you gonna do a notice of withdrawal now? On
Yeah,
my
and
bed
then I'll
and
do a
Rod?
notice of
And then
withdrawal.
you file a notice of entry appearance if you have a retainer
I will
agreement.
talk to Jerry about signing a retainer agreement and doing all the waivers and all that stuff.
Thank you, very efficient, thank you. Okay, thank you.